for pronouncement of judgment and order. Item number 16.
The rival contentions advanced by the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. At the outset, it is made clear that the present adjudication is done independently without being influenced by any observations made by the Honorable Division Bench in the judgment dated so and so. Though certain observations on merits have been made in the said order, more particular in paragraph so and so, necessary clarification have also been made in paragraphs 31 and 32 regarding an independent adjudication. That apart, the Honorable Division Bench was only considering the legality correctness of the grant of an interim order by the learned single judge, which was interfered with by the Division Bench by the aforesaid judgment, and the matter was remanded for expeditious disposal. At this juncture, it is also necessary to take into consideration the preliminary objection taken on behalf of the state that the final order dated 21/2024 of cancellation of the caste certificate not being challenged, no relief can be granted to the petitioner. The said order, which has been brought on record by way of additional affidavit filed on 23/2024, would show that the same has been issued pursuant to the speaking order dated 12/1/2024. It also transpires that the said order was communicated to the petitioner by email on 13/2/2024, and the respondent number 8 has also filed the caveat regarding the said order on 7/2/2024. It is almost a month thereafter. The writ petition was filed on 4/3/2024. Ideally, the aforesaid order of cancellation dated 21/2024 should have been a part of the challenge which has not been done. This court is unable to accept the submission made on behalf of the petitioner that since there was urgency as the elections were approaching, the said order could not be specifically challenged. However, having held that, this court is of the opinion that the order of cancellation being a consequential order of the speaking order dated 12/1/2024, which has been challenged, interest of justice may not permit the petitioner to be non-suited to maintain the present challenge. We are just reading the operative part. This court is of the considered opinion that the findings of the SLSC in the impugned order dated 12/1/2024 cannot be termed as based on no materials. This court is of the further opinion that all the aforesaid factors are relevant and germane to the issue which were taken into consideration, and the order having been passed after giving adequate opportunity to the petitioner, there may not be any requirement for further analysis of the reasons thereof. There is another aspect of the matter which has intrigued this court. The petitioner, who is aged about 53 years and having certain education qualification, and had obtained his caste certificate only in the year 2011, and he had contested the elections from so-and-so parliamentary constituency in the year 2014. There is not even an iota of evidence or any material brought on record by the petitioner at any stage of the proceeding which are prior to the year 2011 pertaining to his claim to belonging to the STP. The father of the petitioner, who was admittedly in service with the Assam Regimental Center, Shillong, also does not possess any document towards the claim of the petitioner. Though the sister of the petitioner claims to be an STP, she had given a statement of belonging to Saranya community, which is admittedly not within the enlisted community in the Presidential Order of 1950, as already held by this court that the surname would not be the determining factor for ascertaining the social status, caste. The materials on record which were considered by the SLC would show that there was no basis for grant of the caste certificate to the petitioner on 14/10/2011 that he belongs to the Boro Kachari community. This court accordingly does not find any illegality or impropriety in the decision-making process, culminating in the speaking order dated 12/1/2024. Writ petition is dismissed.
May I pray, my lord, that the order may be so that I can get early to upload that.
You'll get it within 5 minutes.
My lord.
My lord, Devashish Bora's court is not sitting today. My case is CRP 40/2024 along with interlocutory of application 1084.
Item number?
Item number CRP 40.
No, is it listed?
Yeah, listed.
Item number what?
Item number 5 in Devashish Bora's court.
Please come. Yes, what is your prayer?
My prayer is already will case is going on higher court.
No, what is your prayer now?
Now, my prayer is let the case be listed on 23rd April
23rd
Oh.
April, okay.
for motion hearing.
23rd April, okay. Item number 5, court number 17. On a request made on behalf of the petitioner. Matter is adjourned to be listed on
23rd April.
23rd of April. It's a Tuesday. It's okay, no problem. Tuesday, 23rd April.
Deeply obliged, my lord.
Wait, please, my lord. My lord, Honorable Court number 17, item number 12, my lord.
Yes,
It may be fixed on 25th.
25th. Yeah, for the petitioner.
I am for the respondent.
Taken the consent. Have you taken the consent?
I-
Take the consent. We'll fix it.
My lord, on 10th of April, my lord, one petition was listed before this court, my lord, but that property society is related, my lord. Lordship was pleased to fix the matter on 19th, my lord, tomorrow. Yeah, my lord, in the e-courts, my lord, it is shown that next date fixed on 19/4, but inadvertently, my lord, in the order, my lord, it is shown as 19/5. So, my lord, matter has not been listed, my lord. May I pray for, my lord, in the tomorrow, my lord, as fixed, my lord.
Motion matter.
Motion matter.
Okay, you give a memo. We'll have it.
I beg to mention item number 10 in 12 lordship.
Which court? This court.
Yes,
This-
lordship.
This
Please,
court.
my lords.
Item number 10 in 12
10,
and 12.
10 and 12. Yes,
What-
there is a. Is Mr. Shah, you are there in 10 and 12?
My lords, I am only in 10.
Okay.
Uh,
What
and
first?
Lord-
Let us. So let us first hear what is the prayer.
We are filing affidavit today, lordship, in item number 10.
10 you are for the
Yes.
CGST.
Yes, lord.
So what is your prayer?
We are filing affidavit today. Matter may be fixed next week, lord.
My lord, if it's next week, I have no objection.
Okay,
Please fix it.
who's in the other matter? 12.
12 lordship allow us 4 weeks time to file our affidavit.
Okay,
For the petitioner.
in 12. Okay, first let us pass the order in 10. Is there any interim order, Mr. Shah?
Yes, my lords, there is. That should.
Okay, you tell us the date of your convenience, madam.
Yes, lordship.
Tell us a date. When should we fix this
Lordship,
My
matter?
lords,
after 4 weeks,
24th
any
works
date?
for.
No. First 10.
Any date, lordship. Next.
10, tell us a date.
24th, my lords.
24th. Okay. Item number 10. A prayer has been, the learned counsel appearing for the CGST has submitted that the affidavit in opposition is being filed today. And accordingly, prays for a short accommodation. Full stop. Para. Sri Arsha, who has appeared for the petitioner online, has informed this court that there is an interim order which is required to be extended, and has also prayed for an early date of consideration. Full stop. Para. Matter accordingly stands adjourned to be listed on 24th of April 2024. Full stop. The affidavit that would be filed today is to be brought on record. Para. Interim order passed earlier to stands extended till the next date of listing. And what about
Yes,
item 12? 12,
Lordship allow us 4 weeks time.
yes. On the prayer made on behalf of the CGST, matter is adjourned by 4 weeks to enable filing of affidavit in opposition. And interim order. Para. Interim order passed earlier stands extended till the next date of listing. So we fix a date, is an interim order. List on. Why do you need 4 weeks, madam? List on 13th of May.
Okay. Much of
Yes.
May I please, ma'am? My lord, I beg to mention item number 15 of this honorable court, my lord.
Yes,
Supplementary motion.
yes, yes.
My lord, I pray that I may be allowed to withdraw this writ petition with liberty, my lord.
Item number 4,
15,
15.
15, my lord, supplementary motion, my lord.
motion.
Supplementary.
Sanjeev Boro,
Yes, ma'am. I may be allowed to withdraw with liberty.
Sri A.K. Gupta learned. It was brought by order, right?
Yes. My lord, before vacation, I have mentioned, my lord, in between there is some problem.
Okay, Sri A.K. Gupta learned counsel for the petitioners submits that there is some development for which he has instructions not to press this petition. Full stop. He however prays for a liberty to file afresh. Also heard Sri BTC, anybody?
Aye.
BTC, okay.
I am for respondent 1 to 4.
Also heard Sri J. Hendrik, learned State Council.
I am for the revenue.
Revenue Department, learned Council, learned Standing Council, Revenue Department. State, Mr. Goswami? N. Goswami, State, huh? J. Hendrik.
Not matter.
Huh? State is not a party?
Revenue.
Revenue and the PT.
Okay, yes. J. Hendrik, Revenue Department, and R.B. Bora, learned Standing Council, BTC. Para. Writ petition is accordingly dismissed as on withdrawal with liberty as prayed for.
All right.
Yes,
May I please, Lord? Let me have mentioned item number 13 of this honorable court, my lord.
yes, yes.
The respondents have filed their affidavit in opposition, my lord, in the IA. I may be granted 3 weeks time to file my reply.
1-3.
1 3.
What is the IA?
IA is for injunction, my lord.
You would file your pleadings in the injunction matter.
My lord, the respondents have filed their affidavit in the internet.
Okay. The learned counsel for the petitioner has informed that which respondent,
My lord, the
Revenue Department.
Revenue Department.
that the Revenue Department has filed an affidavit in opposition, which is required to be replied to.
My lord,
Full stop. He accordingly prays for and is granted 2 weeks time,
3 weeks time.
3 weeks time to file rejoinder affidavit.
Right.
I-8, huh? I-8. Is there any interim order?
No, man.
May I please, lordship?
Yes.
I beg to mention item number 6 of this podium.
Item number
6.
6.
As per the instruction of the client, I want to withdraw this case, your lordship.
Hmm?
I want to withdraw this case.
You want to withdraw this
Yes,
matter?
your lord.
What is your name?
Yes, Troy.
Social justice empowerment, anybody? Social justice empowerment. Ms. Sharma, you will be there?
But Mr. Aramdas is it's the standing counsel. But
You can appear on his, he's withdrawing the matter. Sri S. Roy, learned counsel for the petitioners, submits that he has instructions to withdraw this writ petition. Full stop. Also heard. No. You are for the state. Sri S. Barua, learned state council. Finance, anybody? Finance, anybody? Sri H. Aliha, learned standing council, finance. And Sri S. Sharma. Sri Sharma, learned counsel appearing on behalf of Sri R. M. Das, Standing Council, Social Justice and Empowerment Department. Full stop. Writ petition is accordingly dismissed on withdrawal.
May I
Yes.
please, my lord?
Yes.
I like to mention item number 18 of code 17.
Item number 18.
18.
Yes.
My lord, may this matter be taken on 25th of April? Listed.
You for whom?
I am from the respondent, side of the respondent.
You have taken the consent of the petitioners?
And I have
You take the consent, then you make a mention.
like,
May I please, your lordship? I beg to mention a matrimonial appeal for listing. Basically, we have I have been granted the divorce.
Matter of which code?
Actually, this is pertaining to code number 17.
17 only matters which are there in the list, you make a mention.
Okay.
Not for listing. Okay. If there is any urgent matter, we could have taken up.
Much of.
Okay.
My lord, item number 12 of court number 7
Yes.
on next Thursday, 25th. I've taken the cut.
Yeah, for the respond number 1.
Respondent. Yes, my respondent. Surat Khan.
Okay. A prayer for adjournment has been made on behalf of the respond number 1. No, don't say.
Right.
On a prayer made on behalf of the respondent for adjournment, comma. Matter is. Don't say for adjournment. On a prayer made on behalf of the respondent number 1, comma. The matter is adjourned to be listed on
25th April,
25/4. Okay.
deeply obliged.
No interim order.
So 2nd April, my lord.
IA for miscase for what? It was
That was for stay, my lord. That was already disposed.
okay.
May I please, Lord? First of all, I pray for listing of a repetition in motion, my lord. It is the land acquisition matter, my lord.
Bench 5 matter.
Yes, my
Okay. When do you
lord.
want?
Wednesday, my lord.
Wednesday. Next Wednesday.
Yes.
Okay. You can have it on Monday also. Motion
Monday, my
matter.
lord. Obliged, my lord.
Item 5.
বারোটা বাজাতে এবার উঠিম এইটো অকমান কাৰেকশ্যন কৰি এটা অনলাইন কৰিব লাগিব বাৰটাত উঠিম দেই এইটো অকমান কাৰেকশ্যন আছে দুটামান দেখিলো এইমাত্ৰ আইটেম নম্বৰ
Item number 5, my lord.
য়েছ
My lord, in this case, according to the previous earlier order, this matter is regard actual facts or not transfer money. In this regard, from the respondent side, he would like taking into action, my lord. Respondent statement.
It's rehabilitation grant for flood victims. So we have got a detailed list of the petitioners who are entitled, and out of these 19 are not entitled, and from among 19, 2 have already received, and the rest remaining, their bank accounts are not telling. So this has been clearly
how many
reflected.
of you are there
18,
how many of you are there
My lord.
how many of you are there in this
how
petition
many petitions?
18, my lord.
18
18, my lord.
no you said 19
Nine, it ought to happen 18 or 2.
19, my lord. Sorry, my lord. 19.
19 petitioners are there
My
what is your instruction Mr. Barua
Okay, from among this 19.
they are seeking rehabilitation for flood they are the victims of flood
Yes.
okay then what is your instruction
So from what my instruction says, out of this 19, 2 have already received the amount.
which two petition numbers
Petitioner number 1 and 4.
yes what do you say
1 and 4, they have already received.
What do you say?
1 is Jalaluddin and 4 is
what is your name
Samsunara Begum.
your name
R.I. Bhuya, my lord.
Bhuya, Mr. Bhuya, what do you say that on his on the submission that 2 of the petitioners have received the compensation?
My lord.
1 or 4 if I say.
And the others?
And the remaining, there are 2 lots. One, they have given a wrong bank account which is not telling, and the
Okay.
other, the bank details are not correct, for which
And the other one?
No, not 2. There are a set of 2 group of beneficiaries who have been
No,
enumerated.
out of 19, you said 2 have already got the benefits.
Yes.
Remaining 17, what has happened? to them?
Out from the remaining 17, it has been categorized into 2
2 lots, okay.
Yes.
One is the wrong bank account,
Bank account.
and the other details have not been given. Okay. Why didn't you comply with your?
My lord.
I can provide him a copy of.
Was not successfully done. For USA again, petitioner submitted various documents along with the accounts, my lord. But till today, flood relief amount is not credited in petitioner account, my lord.
2 of the petitioners, they have already got the benefit. When was it paid, Mr. Borwa? 2 petitioners, 2 benefit, 2 of 19, Jalaluddin and serial number 1 and
4.
Shamsunera Begum.
Yes.
4.
The
1 and 4.
accompanying page has the details about.
You do one thing. We may not burden you to file an affidavit. These are matters which can be disposed of.
Yes,
You give a copy of your instructions
Yes.
to him, you verify, and you come back to us within 2 weeks. Okay? We'll
Okay.
have it for motion.
Okay, my lord.
Your name? What did you say your name?
R.I. Bhuya, my lord.
R.L. Bhuya.
R.I. Bhuya.
R.I. Part 3 R.I. Bhuya. Are you there on records or not? You're for whom? You're appearing on whose instruction?
Anis Mazhar Bhuya, my lord.
Anisha, okay. R.I. Bhuya, Learned Counsel, appearing on instruction of Sri N.H. Mazhar Bhuya. learned counsel for the petitioners. Full stop. The grievance of the petitioner is with regard to a claim for flood damage compensation. Full stop. Para. On 22/3/2024, when this matter was taken up for consideration, the learned state council was directed to obtain instructions. Full stop. Para. Pursuant thereto, Sri S. Barua, the learned state council, has obtained the instructions as per which, two of the petitioners, namely petition number 1, Jalaluddin, and petition number 4, Shamsunara Begum, have already received the compensation. Full stop. It is further submitted that out of the remaining 17 numbers of petitioners, few have not given the details of the bank account, and the other lot has given incorrect bank details, for which the compensation has not been able to be disbursed. Full stop. Para. In view of the aforesaid facts and circumstances, this court let instructions be obtained by the learned counsel for the petitioners on the aforesaid regard. Full stop. To facilitate the facilities seeking of such instructions, let a copy of the instructions be handed over to the learned counsel during the course of the day. Full stop. Para. List for motion hearing on, we'll have it on 1st of May. Okay?
Yeah.
Wednesday. We'll retain a copy of this. You have a copy? You don't have?
I will just.
We will
Copy.
photocopy it. Yeah, for it. One, give a copy to him also. I mean, photocopy রাখি to you.
Play.
আমি এটা কাম করো নাকি অর্ডার্স কিনে হেক করে দাও নাকি হ্যাঁ অর্ডার্স কেটা আছে না
Made critical.
yes
My lord, in this matter, my lord.
no just a minute. This top of the list are old matters, so we'll
Yes.
be trying to go for a final disposal. We'll do one thing, we'll finish the orders matters first, because otherwise the council will remain sitting. Orders at any admission kit here. Admission orders. যদি disposal কাৰণে হয় তেতিয়া নলওঁ কিন্তু orders যদি আৰু হেৰি admission আৰু orders মাতি দি we'll finish the admission and orders, but if it's for disposal, then we'll not take, we'll give preference to the old matters. অকমান হেৰি অকমান ৰখাচোন
Item number 7.
It's
Just to make kindly take up this matter after some time. My senior is on leave.
okay, we'll have it after some time. Just a minute. অকমান পিছত পাতিব
After some.
Biplop. Paragraph 57. Change no korba, paragraph 57 not S, 57 not S, letter, paragraph 46. It, which he has, he's to cut it. বাকি এবার চাইলে বাইটু তুমি এটি অনলাইন করে ওখান দেরি হয়ে যাবে না বর্ণনা লাগে না উঠে তুমি করে যাবে চাইলে ব্যাপার খালি করে দিবি বা 12টার পিছত করলে করবো পারে হ্যাঁ 12টার পিছত করলে করবো পারে yes
After some time.
okay item number
7.
yes what is the matter Mr. Bhattacharya?
My lord, it's the construction of a national highway from Jaji to Dimo.
Okay.
The contract was given by NHIDCL to GDCL. Now the prime contractor is GDCL. For construction of the road, they have to ship the water pipelines of the Public Health Engineering Department.
Okay.
For that purpose, they have given a
Contract
subcontract to us.
Okay.
Now, as per the contract agreement signed between NHIDCL and GDCL, the first, the GDCL has to pay us the money, the running bill amount. Then that will be
I think one
reimbursed by
matter already
GDCL.
decided, isn't it? Jaji to Demo, 2 parts. Mr. Saikia was appearing.
Yes.
The main contractor was not getting the amount.
Yes.
We have held that.
Already lodged by Philippine opposition.
Okay, in this matter.
Yes, we have already paid the utility service payment. Already we have released.
That is the thing, man.
Ah.
They cannot bypass it. First, they have to ensure.
Just a minute, just a minute.
More than 3 crores, Lord. So we have released the amount, and the petitioner is not a contractor under us. He is a
Okay.
subcontractor under the
But
petitioner.
your, the contract, it allows subcontracting, if you remember correctly. This is a peculiar contract where
Yes,
subcontracting is
yes.
allowed with the consent.
Actually,
Yes.
the subcontractor actually engaged some subcontractor.
No, no, it is allowed.
Yes.
This,
But
where,
we have released the amount, Lord. The utilities are more than 3 crores.
is the,
So,
or is the principal contractor a party?
Yes, yes.
Who is appearing for him?
The council appeared, today he's not appearing.
Who is appearing? Whose name is there?
Mr. Some Deuri, Mr. Deuri is appearing.
SK Deuri.
Yes.
SK Deuri.
Where is Mr. Deuri? R8. Okay, try to bring him also. You're led by Mr. Chaudhary?
Yes.
Okay, we'll have it after some time, madam. Okay. But if we start the old matters, then this will go later, okay? We'll give preference. We'll just want to finish up the admissions and orders.
Immediately.
Lord, I have to file a petition because I'm not registered.
The main party, my lord, BPCL, my lord, Bharat Petroleum, my lord. In the earlier occasion, my lord,
I didn't file the affidavit. BPCL has filed or not?
not my lord.
Who is appearing for BPCL?
My lord,
Served or not?
Notice they would-
notice already served, my lord, in the first date, my lord, he also.
Mr. Bhattakur, where is Mr. Bhattakur?
S. Bhattakur.
S. Bhattakur. Mr. Borwa, S. Bhattakur, who appears for the BPCL normally. Okay, try to bring him. We'll pass the orders. He will also like to file affidavit.
I'll go to file, my lord. Welcome.
Mr. S.S. Roy is with him normally. Mr. Borwa. S.S. Roy is normally with him. S.S. Roy and S. Bhattakur. Oh,
S. Roy also appeared, my lord, as TGS.
oh. Heard 3. K.R. Padgiri, Learned Counsel for the petitioner. Puts the para. Both 3 C. Barwa, Learned Standing Counsel, NHAI, as well as 3 June Hoy, as Bhattakur, Learned Counsel, appearing for the BPCL. Pray for and are granted 3 weeks time to file affidavit in
Yes,
opposition.
fully file it.
List of 3 weeks.
That may
Is
be
there
fixed,
any
my lord.
interim order? No.
No, my lord, that may be fixed, my lord.
Yes, tell us.
I am
List on,
awaiting-
list on today is 18th. We'll have it on 13th. List on 13th of May.
My lord, obliging.
Okay.
Second line.
May I
Fine.
please dot it?
Yes.
Affidavit is sent for vetting sometime.
Okay. Ms. S. Barua, learned State Council,
Yep.
submits that the affidavit in opposition has been prepared and has been sent for vetting, full stop para. On request, list after 2 weeks to enable filing of affidavit in opposition.
Lord, pick a date, Lord.
List on 1st of May, 1/5.
Complex.
Diplomat.
Yes,
May I please? The matter pertains to cooperative society, like time will be required for hearing also.
affidavit filed.
Affidavit not yet filed by the,
Then where is Corporation Department? Mr. Talukdar, Madam Bora. There are 2, 3, Miss, not you.
I will.
Bora, then we have Bordoloy also, G. Bordoloy. 3 councils are there, standing council, Corporation Department. They have not filed affidavit. Try to bring them, they might require time to file affidavit.
Lord. I will inform Lord.
Okay. এটা না? That's what it is. Yes.
My lord, in the IA, my lord, that is implement petition, my lord, other side, they have taken time to file objection, but till date, they have not filed objection and they are enjoying the benefit of the interim order, my lord.
My lord, today itself we are in process, my lord, in filing, my lord, sometime may given, my lord.
But if you don't file it today, will not allow you.
My lord, today, my lord,
You want yourself to be implemented in the.
Yes, my lord.
Okay. Hmm.
They may file objection in the vacated
You are Hassan,
petition.
K.
my lord.
Hassan.
yes, my lord.
Hertz MSSB Chaudhary, learned counsel for the applicants who has filed this application for their impleadment. Full stop para. Sri K.M. Hassan, learned counsel for the opposite party writ petitioner, however, submits that the affidavit in opposition,
My lord,
objection affidavit would be filed during the course of the day.
Right.
Full stop para. We'll have it on Monday, madam.
Yes.
List.
till then, my
on-
lord, interim order may continue.
List on Monday. List on, give the date, please. 22, along with the objection affidavit. I hate Likhiba. Para, interim order passed earlier to continue till the next date of listing. Hey, do it at Likhiba. Interim order to Likhiba, na?
My lord, it may be on 23, my lord, may it push.
Okay, on 24th then, 24. Budbar,
Obliged.
interim order থাকিলে, do it at Likhiba day এখন. Yes.
11. I did 11.
Cooperation, madam, you are not cooperating.
This matter is handled by S. Talukdar, Sabon Taluk. I will inform him, my lord.
You will not cooperate, he'll cooperate.
I'm also standing counsel, but this brief is not
That is
with
it,
me.
you are not cooperating, he is cooperating. Okay,
But
who
this
was
is
there?
also absent.
Who was there in this matter? Huh? M.K. Hussain. Now you are not cooperating. Cooperation department is cooperating, you are not
Sorry, ma'am.
cooperating.
Sorry, man.
Okay, where is Mr. Arukdar? You have not filed your affidavit.
He's coming.
Maybe he'll file the affidavit, we'll grant time, we'll record his name.
Affidavit
Yes,
will
yes,
be,
my lord.
affidavit will be required, Lord.
Okay.
We'll file. I will inform him, my lord.
Okay. Heard Sri M.K. Hussain, learned counsel for the petitioner. Full stop. It appears that the Corporation Department has not filed the affidavit in opposition, for which some time is sought for. Full stop para. On request, list after 3 weeks
Lord,
to enable filing of affidavit in opposition.
Any date, Lord, any,
Okay.
any date.
Okay. List on the 3rd of May.
I'm deeply obliged, man.
Is there any interim order? Interim order passed earlier.
Obliged,
Stands extended till the next date of listing.
obliged, lord.
Mr. Roy, BPCL matter. One matter where BPCL is there.
Item number.
Mr. Borthakur had appeared earlier, but his name I don't think has been shown. Date to deliver. 13/5. You take note and registry to reflect the name of Sri S. Borthakur as counsel for the BPCL.
I think Lordship, we have filed our Vakalatnama out.
Maybe we do not know.
Good.
In the last order we found his name.
Lordship.
We got some. Onto timing onto us here. Yes, 7. Okay, this will go.
Can it be on some other day?
No, this will go after the this thing, after the list. If there is time, otherwise we'll fix another date. Okay, let us see the top of the matter, top of the list matters.
Right.
You were like,
Can it be taken up on 3rd?
Yes,
Third.
madam. 3rd.
3rd of May.
Item number 7. A prayer for adjournment has been made on behalf of the petitioner. Full stop. Also heard Ms. R. Bora, learned standing counsel NHIDCL.
and it said 1 to 4.
Respondent was 1 to 4. Who is for PHE? RR Gogoi. Learned standing counsel PHE. Full stop. Para. As requested, list on 3/5.
3/5. Interim order.
Para interim order passed earlier to continue to the next date of listing.
Okay.
Yes, please.
My lord, in this matter, my lord, in the year 2009, the IOC, Indian Oil Limited has taken possession by providing Zirat value, my lord, and
2009.
9. And I was-
Your land was taken over by the IOC.
Yes, they
by the
possession
Indian
has-
Oil.
Yes, yes.
All India.
Oil,
Oil
India.
India.
Oil.
Land of petitioner. They took over possession.
Yes, my lord.
No acquisition proceeding.
Yes, my lord.
Right of way.
My lord,
Under what provision of law the possession was taken over?
my lord, that is not there, my lord. Without my humble submission is that, my lord, the oil has taken the land without following the procedure of law, my lord. As because, my lord, the respondent authority has not been issue notice under Land Acquisition Act, my lord. My lord, I was an impression that the compensation amount will be given, my lord, after completion of proceeding, but the amount has not even informed to me, my lord. But the amount of Zirat has been given.
Zirat has been given.
Zirat given, my
How
lord.
much amount?
My lord, amount I have not mentioned here, my lord, but I have no grievance regarding the Zirat, my lord.
Okay. You are on the acquisition aspect. The
Yes, land, my lord.
land acquisition.
Land compensation, yes.
Okay. Compensation for the land acquisition.
Yes, my lord.
Okay.
In the year
It was
2000,
your Patta land.
Patta land, my lord.
Okay. Okay.
In the year 2011, the son of the petitioner, original petitioner, my lord, had made an application under Right to Information Act
Hmm.
for knowing the value of the land, my lord.
Hmm.
Only on that reply, the Land Revenue Authority has informed me that the value of the land was fixed at 5 lakh rupees per bigha, my lord. But, my lord, in the year 2010, some other similarly situated person has got compensation at the rate of rupees, my lord, 10 lakhs 7,872 rupees per bigha, my lord.
Rupees 10 lakhs.
10 lakh, my lord,
Okay. Per bigha.
per bigha.
Okay.
That, my lord, I have approached this honorable court, but the oil has not informed me about the rate. Signature has also been taken for sale permission, my lord, sale permission application. In a sale permission application, the value of the land has been mentioned as 4 lakh, my lord.
The land has been purchased from you.
Supposed to, but nothing has been done. Only the respondent authority asked me to submit documents for preparation for sale deed, my lord. But I was not submitted to the authority, my lord.
No,
Because
is there any registered sale deed of the land?
yet to be registered, my lord.
Not registered.
Not registered.
Is there any agreement to sale?
No, my lord, nothing.
No, you said that you have signed the sale permission.
Yes, my lord, for permission, they have taken my signature. But after that, nor before, any agreement has been
So
executed.
see, there are two aspects. One is which you are trying to claim is a compensation aspect. One
Yes.
is the value of the land as a price.
Yes, my lord.
Now, if you are aggrieved, see, if you have signed the application for sale permission,
Yes, my
that
lord.
means you are agreeable even for sale of the land, you want the proper value of the land. Whether it is by acquisition or sale, that may not be the deciding factor. The
Yes,
deciding
my lord.
factor is whether you get the proper value.
Yes, my lord.
Now,
That is-
if you have not got the value,
Yes.
don't you think that you can approach the civil court for either a specific performance or whatever? The possession is with them.
Yes, my lord.
Possession is with them.
Possession with them.
Now, the value of the land has not been given
Not
to you.
even, my lord.
We can ask them what is the value they are offering.
My lord, I have no knowledge about the value also, my lord. What is the value has been fixed for the land, my lord. I was asking again and again, my lord, but
No,
they
see,
have,
Mr. Saikia, if you are entering into a private contract,
Yes.
maybe with the oil or anybody,
Yes,
that your land would be purchased by them. So in that case, it is the meeting of minds between the parties to the contract, what value you agree upon. Now, your contention that you do not know the value, those will be relevant if the land is acquired, compulsorily acquired when you do not know what price will be offered to you. You can say that I am entitled to a higher price
Yes.
because adjacent lands or maybe many factors, you know,
Yes,
what are the
yes.
factors. But this is a private negotiation. You are selling the land.
yes, my lord.
Now,
Right.
for the price, whether we can be of any aid to you, whether you can come to read court for determination of the price in a sale transaction.
Yes, my lord. My submission is that, my lord, I have to discuss with the authority. Authority has to discuss with me regarding the value for
Yes.
fixing the value.
Correct.
But that was not done. But I was an impression that land will be acquired, my lord.
Now that impression, once you sign the sale permission letter,
Yes,
maybe
please.
sale till now it's not registered. That's a different aspect. But we rest assured that we will not leave the matter like this. We'll try to ensure that you get the proper price. But price has to be at the time when the actual land was transferred to them or they had taken over possession.
Yes, my lord.
Yes, Mr. Chaudhary, you are for Oil India Limited.
Oil India, ma'am.
Okay.
May I just place the fact, with greatest respect, my lord, the correct facts have not been raised. First, your lordship will kindly come, your lordship will kindly take up, we have filed an additional affidavit.
Yes,
It starts from page
55.
55.
Yes.
The lordship will straight away come to page 71. We are bound by the, my lord, the revenue fixed by the authority. And this is the
Page 71.
page 71.
Mr. Saikia, take a seat. We'll
Yes.
come back to you. 71.
Page 71. Annexure R6. We are concerned with semi-urban area and around Tinsukia town. And the value fixed, your lordship will find is 5 lakh. Now,
Yes.
the the procedure that we adopted was, we wanted this land for our oil exploration, etc. And we wrote to the revenue authority, which your lordship will find at page 76.
Yes.
Total land in question that we wanted was 19 bighas and 10 lesser.
Okay.
We wrote to the circle officer. May I read it?
Yes, yes.
We are in the process of acquiring a plot of land measuring 19 bighas, 0 kathas, 10 lessas involved in oil's drilling location so-and-so, falling in village Lohari, Pongali, etc., West Makum, as per so-and-so. We shall be grateful if you would kindly issue us the Chitha, cadastral map and field verification report, land chart showing the DAG number, patta number, etc., etc., names of the pattadars, occupiers involved in the above mentioned location at an early date, please. The above mentioned data is required to make the bipartite settlement with the pattadars, occupiers and payment of land value to the rightful owners of the land towards permanent acquisition through outright purchase. Now, based on this, they provided us the material, which your lordships will find from page 77 onward.
Yes.
They provided us the particulars of the landowners. I am just drawing your lordship's attention to serial number 3. Your lordship will just make a note of at page 77, serial number 3, Vinod Mahato. I'll come to this later, the significance of this one.
What is the name of the petitioner?
Petitioner is in the next page, man, serial number 7.
Okay.
Monindranath Asajja. Now, once we got these details, we approached them for purchasing this land.
Okay. Petitioner is at page 78.
78.
Next page.
78.
Where are you?
Serial number 7.
Suchil. So Monindranath.
Monindranath. Okay.
Okay.
Now, once we got these particulars, if your lordship will kindly turn to page 80.
Yes.
First, we immediately made payment of the Zirat.
Okay.
And we also wrote to him this letter. So it is wholly incorrect to say that he was not aware of the price. This is a letter from Oil India to the petitioner.
What did you say here?
Kindly accept our gratitude. This is hereby informed that we have already initiated necessary steps for payment of the land value of registered patta land of yours, which is acquired by Oil India drilling purpose at rupees 5 lakhs per bigha. This is the amount fixed by the revenue authority. As has been fixed by the Deputy Commissioner Tinsukia within 3 km periphery from boundary of Tinsukia town. The land value will be paid after obtaining the sale purchase permission from Deputy Commissioner Tinsukia and after execution of sale deed at the office of the sub-registrar. Therefore, you are requested to deposit the following documents at our office. We ask for these documents and your lordship will kindly note serial number 5, signed joint application for sale purchase.
Yes.
Based on this, he in fact submitted.
Yes.
If your lordship will kindly come page 82. Once he submitted these documents, including the application for sale permission, we are now writing page 82. We are now writing to the Deputy Commissioner.
Yes.
Reference to the subject cited above, we enclose herewith a joint application for granting sale permission towards the land schedule as mentioned below. And your lordship will find the particulars of the petitioner's land. And at para 2, your lordship will find, in this regard, we enclose the photocopies of the following relevant documents for your kind perusal. We submitted all this. We'd like to, in this regard, we'd also like to mention that the subject land is under oil's possession since 12/12/2009. Accordingly, as per your letter number so-and-so of so-and-so, regarding the land value payment based on the land chart, the rate applicable will be 4 lakhs per bigha, etc., etc. And now, if your lordship will kindly turn to
page 85, your lordship will find the application for sale permission. And your lordship will find the petitioner's signature at the next page. And so far as the petitioner is concerned, your lordship may just like to make a note of the land. It is 4 bighas, 1 katha, 1 lesa out of the 19 bighas odd. We are, so far as the petitioner is concerned, it is 4 bighas, 1 katha, 1 lesa. In respect of all others, we follow the same.
Where do you get?
This is not in dispute. This
No, the total is 5 bigha, 1 katha, 1 lecha. Page 85.
page 82.
No, 85. If you come towards the last part, dark number so and so, total 505-1-01.
So it should be permission applied for. If your lordship will kindly come back to page 82 for a moment.
82 have seen 4 bigha, 1 katha, 1 lecha.
One. That is the quantum of land for which we applied for sale from. That is not disputed by the petitioner. There is some in this handwritten portion, there is some confusion. But when we applied, this is the page 88 also reflects, I'm told.
See, there is, I think,
Page 88 is the NOC ultimately, the permission that we got.
80.
Page 88. One bigha, 3 katha, 1 lesa plus 2 bigha, 3 katha. Page 88.
Page 88 is 1 bigha, 3 katha, 1 lecha.
And there is a comma. Thereafter, there is another 2 bighas, 3 katha. So it adds up to 4 bighas, 1 katha, 1 lecha.
Four B, 1K, 1L.
Well,
okay. Then,
and if your lordship comes back by a page 87.
Yes, please.
This is again a communication to the petitioner. Sir, with reference to your letter dated so and so on the above subject, we would like to inform you that by our letter number so and so, we have already applied for sale purchase permission to the deputy commissioner, etc. On receipt of the requisite permission only, we shall be able to make the payment of land value on execution registration of sale deed in the office of the sub registrar, etc. Now, my lord, in the intervening period, there is one development that I must point out to your lordship. There is an affidavit in opposition which file which starts at page 31.
By you.
Yes. In that, if your lordship kindly comes to page 40. So, they submitted this declaration, not just the petitioner. They submitted this declaration. 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 They submitted this declaration
the owners of all the remaining portion also, total of 19 bighas odd, after receiving the compensation for Zirat,
Page 40, where is the
page 40,
where is the petitioner here?
serial number 13,
40, page
40,
serial number?
13. It's a handwritten. If your lordship, the original is at the next page. Your lordship will kindly. At serial number 13, your lordship will find the petitioner's signature. M. Athar.
While making the type copy, you had missed out the main part. Page 40, it does not have his signature. Page 41.
Page 41 is the original. Now, after following all this procedure, if your lordship,
What is this actual declaration?
it is a declaration
Surface count declaration.
that they have received the compensation and they have handed over possession to us.
What compensation?
Compensation for the Zirat.
Jirat. Receipt of compensation.
And this is not just the petitioner, this includes all the patadar. Now, my lord, after following all this procedure, once we receive the sale permission, except the petitioner, if your lordship comes back to the additional affidavit, the reason I pointed out that Mahato person, Vinod Mahato, his sale deed, your lordship will find at page 101.
101. 101. Yes.
Between Sunu Mahato and second is Vinod Mahato, that person that I had shown. And with respect to all others except the petitioner, everyone came forward, we executed the sale deed, made the payment.
This was a common sale deed.
No, so separate sale deeds are there. The sale deeds start from page 89 onward.
Okay. This is a sale deed of Vinod Mahato.
Vinod Mahato. So all others, your lordship may note that except the petition, everyone executed the sale deed, took the amount, because that is the amount fixed by the revenue authority and we are bound by it. It is at this stage that the petitioner got wiser and he filed this writ petition asking for a higher. Your lordship, if your lordship sees the prayers, there are 3 prayers made. If your lordship comes to the prayers made in the writ petition,
Just a minute.
in fact, we have been repeatedly telling him it's on record. Page 14 will. Page 44.
Page
44 will show that we have been requesting him that come forward of the affidavit in opposition.
$44, yes. Yes.
As I was pointing out,
You wanted to show the prayer?
your lordship will kindly see the prayers made. There are 3 prayers made.
Yes.
By way of a writ petition, he is now asking for a certiorari to set aside the amount of 5 lakh. And thereafter, further prayer, mandamus for enhancing it to 10 lakh. So as had rightly fallen from your lordship, would your lordship invoke the writ jurisdiction for all this? This is a outright or a sale and purchase arrangement.
Okay.
Now, an identical issue with regard to Dibrugarh had arisen before this honorable court. And a division bench of this honorable court has in fact held that we are bound by the revenue fixed by the authority. I just wanted to point out that in this also, although the repetition was entertained, ultimately it was dismissed. It was not dismissed on the ground of maintainability. But one thing I wanted to point out,
Yes.
if your lordship will come to para 19,
Where was it, DB? It's a writ petition.
well, para 19.
Yes.
Here also, well, if your lordship peruses para 19, your lordship will find that it was just, they were just asking for an higher amount.
Yes.
And at para 22, the division bench has held that we are bound by the rates fixed by the district administrator. Para 22, a very first sentence your lordship will find. In view of the fact that admittedly computation of the surface compensation as well as the value of the land to be acquired for the oil has to be essentially at the rates fixed by the district administrator. We are of the unhesitant opinion that the amount already paid for the Ziraat and the offer towards value of the petitioner's land are on the basis thereof. So this is exactly what we have done. And this is the procedure that we follow. We first approach them for an outright purchase. And this matter, they had taken it to the Supreme Court, and that was also dismissed. So therefore, my lord, in my respectful submission, even on the merits of the case, perhaps the petitioner does not have much for it. And that submission always remains, my lord, whether your lordship should entertain in a writ proceeding. I am not going to the extent of the petitioner's conduct, but perhaps the conduct also has not been very fair. All along he was aware of.
Okay. No,
What
only
was-
one thing is slightly, it's a matter, we are slightly concerned.
Mal.
Here, the rate is 4 or 5 lakhs.
5 lakhs.
5 lakhs. That is a mistake, perhaps.
Yes, perhaps that 5 lakhs.
No, why it's written as 4 lakhs?
That can be worked out from the payments made to the others, my lord.
No, if you come to 14/5/2010, the letter at page 80 something, 81, I think. (14/5) is 80. 80 is your letter.
Yes, here it is indicated as 4 lakhs. I will check out.
No, here it is indicated as 5 lakhs. At page 80.
Page 80 it is
5 lakhs, then it come to page 82, it is becomes 4 lakhs.
4 lakhs. I'll
And the government value is 5 lakhs.
I will just check. Itu চারিটা But
Wow.
my instruction is otherwise that indicate for us.
And what was let us see we have seen had a cursory look at the sale deed with Mahato. The only total amount is written. Let us see, it's 48 lakhs. How much is the land?
Mahato's land is
48 lakhs. 9 bigha.
9 bigha tea.
No, let us see. What is the rate?
Huh.
Hmm. Uh-huh.
Huh. In fact, my lord, this the fact that it is 8 lakh, 5 lakhs, if your lordship comes to one of the cell deeds, my lord, at page 89,
Hmm.
this
Yes.
person has exactly 1 bigha,
Okay.
and it has been told, page 89, the cell deed start, and if
Yes.
your lordship kindly comes to page 91, this will show that the amount is 5 lakhs for 1 bigha.
5 lakhs. Yes, Mr. Saikia.
Yes, my lord. My lord, I like to draw attention to page number 45. That is affidavit in reply filed by the royal, my lord.
Page 45.
45. That is vernacular, my lord, in the translated that 44.
Just a minute, please. Page 45. Saikia. Page 45.
Yes, your lordship.
Yes, please.
He mentioned that, my lord, এই ক্ষেত্ৰত আমাৰ তৰফৰ পৰা আপোনাক মৌখিকভাৱে অনুৰোধ জনোৱা হৈছিল যদিও আজি পৰ্যন্ত আপুনি ওপৰত উল্লেখ কৰা নথিপত্ৰসমূহ জমা দিয়া নাই। But in the additional affidavit, my lord, it is stated the oil has communicated to me, to the petitioner, by issuing a letter by dated 14/5/2010, wherein it is mentioned about the documents, my lord. But as I
14.5, where additional?
my lord, the page 80.
Eight zero.
Yes, your lordship.
80.
Whereby the respondents claim that the rate has been communicated, my lord.
Yes.
This letter, if issued, my lord, the subsequently, the letter dated 2/8/2012 may not mention that verbally they have communicated, my lord.
What is your submission?
I want to submit that, my lord, I have not received any letter from the respondent, my lord, regarding the rate, my lord, which was I have mentioned in my rate petition, my lord.
Now, what about this? How have you dealt with this submission and these annexures? Have you filed a rejoinder?
Yes, my lord. I have filed rejoinder, my lord.
Let us see the averments connected to page 50.
Sorry, my lord. Sorry, my lord. After additional affidavit, I have not.
No, let us not take into let us take into account page 45.
Yes, my lord.
The relevant annexure R4. R4 is in connection with the averments made in paragraph 9 or 10. 9. Let us see your reply affidavit. Have you? Nine.
Here I have mentioned, my lord, that the statement made in paragraph 9 of the affidavit in opposition regarding telephonic information to the petitioner is being land sale purchase permission for the office of the deputy commissioner in respect of the land of the petitioner and issuing letter dated 2/8/2012 by the company, and again making the request to furnish document etc. are denied by the deponent as false and concocted and has been made to cover up the inaction of the respondent authority method.
And who is this? There's somebody who has received this on your behalf. Page 15. The running page 45, annexure R4.
Yes, somebody has signed, my lord.
It was a common plot of land, adjacent.
my lord.
All other sale deeds have been executed. Now, your contention whether the rate is proper or not, that's a different aspect.
Yes.
You are on a different footing altogether. That you are kept in the dark, you do not know the rates, and therefore the thing has not materialized. You have
Yes,
got
my
the
lord.
jirat, you have got nothing else.
Yes, my lord.
But is it an acceptable kind of a proposition or a projection of facts?
My lord, my submission in this regard is that, my lord, if the authority acquire my land following the procedure of the
It is not an equation. We have
Mm,
seen from the
yes, ma'am.
letter, they try to go for an outright purchase.
Yes,
If it
my
is
lord.
possible, if it is not possible, they take the recourse of the Land Acquisition Act
Yes, my
through
lord.
the Deputy Commissioner. Now, it's a matter of an outright purchase. There is on record, there is a document towards seeking permission for sale where you have signed.
Yes, my lord.
And thereafter, you have not done anything. Have you denied the sale permission letter?
No, my lord. I have not denied
Then
regarding sale permission, my lord. Only my submission is that, my lord, the rate is lower rate, my lord. And in this regard, my lord, I want to submit that, my lord.
no, if the rate is lower, if the rate may be lower, but it's a private negotiation.
Yes, my lord. If
You
the,
should have said, no, I'm not going to offer at this rate. You acquire my land.
yes, my lord, the petitioner was a illiterate person, my lord. He does not know, my lord, regarding acquisition procedure, etc., my lord. Because of that, if considering the my lord impression that the land will be acquired in proper procedure,
You are not an illiterate person. What do you know?
he can sign, my lord. He can
Do you
sign.
know what is the meaning of illiterate?
Illiterate, I am
You
signing in the
cannot
sense
read or
that,
write. That is the meaning of illiterate. You may not be highly educated, but you have signed in English language.
yes, he can sign, my lord. He can sign.
And you have nice handwriting.
My lord,
These are not conclusive, but these are indicative that you know what is going on. Your projection that you are illiterate, you do not know.
my lord, even the constitution itself says that the land should not be taken, my lord, acquired below the market price, my lord.
You should have said, no, I'm not going for a private recognition. Others might go. I'm not concerned. I'm not interested. I want a higher rate. I'm not agreeable. You acquire whatever you do. You have not done that.
Yes, my lord. That is correct, my lord. But thing is that, my lord, as per the Land Acquisition Act, if prohibited to some authorities, the penalty provision is there, my lord. So,
If it was a case of acquisition of land, matter would have been different. You are stopped by your conduct. You signed the sale letter, sale permission letter. You have not denied your signature. And having said that, you say, no, I'm not interested in sale. I want an acquisition. If you go and, where is your conduct?
my lord, regarding conduct, my lord, the rate, the petitioner has communicated for the rate, my lord. But the rate was not communicated.
Rate will say the rate existing, which is appears to be 5 lakhs. There is a reference to 4 lakhs. Are you disputing on the area? Are you disputing?
No, my lord. Regarding area, I have not
Area is
disputed.
not. So no, there was.
Not regarding Zira.
It appeared that there was one bigha less. It's not. It's correctly written.
My lord, that is calculation.
Okay.
Mistake of
Then
calculation.
even that controversy is not there. Then nothing to be. I don't think this matter should have been kept pending for all these years.
My lord, may I pray in this stage, my lord, regarding, my lord, if the authority wants the land, my lord, they are in possession, my lord, they continue to keep in possession, my lord, then they may proceed under the Land Acquisition Act, my lord.
That is neither your prayer nor your conduct will allow us
Yes,
to
my lord, that
consider
was
that
not
prayer.
my prayer, my lord.
Neither your conduct will allow us to consider such a prayer. You proceed in a different direction along with others. Others have got the money. But we'll say something that you complete the formality within a month, they'll finish up the sale deal.
My lord,
My lord, if my presence is not required, there's a part heard matter.
Okay.
Deeply obliged.
Yes, we will dictate now.
My friend will be here.
Okay.
my lord, I like to draw attention to a judgment passed by the Apex Court, my lord.
Yes.
Volume 2013, 1, Supreme Court cases 353. Here, my lord, in paragraph 8,
Give the citation, please.
my lord, 2013, 1 SCC,
2013, 1 SCC,
1 SCC, 353.
353. Name?
Name, my lord, Tukaram, Kana, Tusi, and others.
Tukaram.
Tukaram,
Tukaram.
Tukaram, Tukaram.
Tukaram. What is the paragraph?
Paragraph number 8 and 9, my lord.
What has been said?
My lord, in paragraph 8, it is stated, the appellants were deprived of their immovable property in 1964 when Article 31 of the Constitution was still intact and the right to property was a part of fundamental right under Article 19 of the Constitution. It is pertinent to note that even after the right to property ceased to be a fundamental right, taking possession of or acquiring the property of a citizen most certainly tantamount to deprivation, and thus deprivation can take place only in accordance with the law, as the said word has specifically been used in Article 300A of the Constitution. Thus, deprivation can be only by resorting to a procedure prescribed by a statute. The same cannot be done by way of executive fiat or order or administration.
Mr. Saikia,
caprice.
how is it going to help you? Tell us.
Regarding, my lord, the procedure.
How is it going to help you? The Supreme Court, Honorable Supreme Court has made it clear that this was an acquisition procedure. Our possession was taken prior to 1964 when Article 31 is in existence. That was a part of the fundamental right. Now here your possession has been taken much later. And this is a matter of regarding acquisition. Here there is no acquisition.
No acquisition, my lord, here.
Okay.
Therefore, I submitting regarding fixation of rate by the authority, my lord, revenue authority.
Okay.
It should be negotiated, my lord.
Heard. 3 M. Saikia, Learned Counsel for the petitioner. Full stop. Also heard. 3 I. Chaudhary, Learned Senior Counsel, assisted by 3 A. Sharma, K. Kolita, for the Oil India Limited. Any state respondents?
Here for 1 to 3.
Oil India Limited bracket, respondent was 1 to 4.
1
And
4 is the district collector.
1 to 1 dash 3, as well as 3 3 and Goswami, Learned State Council for respondent number 4, and 3 A. Bhattacharya, Learned Standing Council, Revenue Department for respondent number 5. Full stop. The writ petition has been filed with the following prayers. Prayer to put Korea, page 15. Interim to nalage. interim na aggregation para. The facts projected is that patta land of the petitioner at measuring 4 bigha, 1 katha, 1 lecha were taken over possession by the Oil India Limited in the year 2009. Full stop. Though the receipt of Jirat for the land in question has been admitted, comma, the primary contention is that no acquisition proceeding was ever initiated, and no notice required for the said purpose was ever issued. Full stop. It is contended that by taking recourse to the Right to Information Act, right to 2005, comma, the value of the land as per the government's fixation was ascertained, which was stated to be rupees 5 lakhs per bigha. Full stop. It is also contended that similar persons whose lands were taken over by the oil were paid compensation at the rate of rupees 10 lakh per bigha in the year 2010. Full stop. The learned Sri Saikya, the learned counsel for the petitioner, has submitted that the entire transaction was done in a hush-hush manner without there being any transparency. And even the rates were not made known to him. Rates were not made known to him. Full stop. It is also submitted by the learned counsel that the rates otherwise fixed by the government at rupees 5 lakh per bigha is wholly inadequate, and the same should be fixed at rupees 10 lakh per bigha, and this is precisely the prayer in the writ petition. Full stop. Sri Saikya, the learned counsel, accordingly submits that appropriate directions be issued for payment of the compensation at an enhanced rate. Full stop. Para. Per contra, comma, Sri Chaudhary, learned senior counsel, for appearing for the Oil India Limited, has submitted that the facts projected on behalf of the petitioner are not correct, and there has been suppression of material facts. Full stop. He has submitted that in the instant case, the Oil India Limited has filed an affidavit in opposition on 16/8/2013, followed by an additional affidavit in opposition on 28/8/2023. Full stop. It is submitted that as per the prevalent practice, comma, whenever there is requirement for any land, comma, the same is at first attempted to be purchased outright, and on failure to do so, comma, the recourse is taken for acquiring the land by following the procedure laid down in law. Full stop. It is submitted that in the present process, comma, certain lands were required, and out of the same, comma, 4 bigha, 1 katha, 1 lacha of land was owned by the petitioner. Full stop. It is pointed out that so far as the other owners of lands are concerned, comma, the sale transaction where transactions were duly completed and there is no complaint whatsoever. And it is only the petitioner who had refused to cooperate in completion of the sale transaction. Full stop. In this connection, comma, the attention of this court has been drawn to the application for sale permission jointly submitted by the parties, in which the petitioner has put his signature. Full stop. It is also submitted that similar applications were submitted by the other owners which led to completion of the sale formalities in the form of sale deeds registered before the appropriate authority. Full stop. The attention of this court has also been drawn to the no objection certificate dated 30/4/2012 in respect of the land of the petitioner in question. Full stop. The learned senior counsel has also referred to the communications by which the petitioner was requested to cooperate and give the further details so as to complete the sale formalities, in spite of which no steps were taken by the petitioner, leading to a stalemate. Full stop. It is submitted that when the petitioner himself is at fault, comma, he is not entitled to any relief from a court of equity. Full stop. Para, the senior counsel has also referred to an order dated 26/6/2012 of a division bench of this court passed in WPC 5449 of 2011. Full stop. It is submitted that the facts and circumstances were similar pertaining to the district of Dibrugarh. Full stop. In paragraph 22 of the said order, comma, it has been laid down that the rates fixed by the district administration are to be adhered to to determine the compensation. Full stop. This court has also been informed that though an SLP being SLP number 36779 of 2012 was filed in the Honorable Supreme Court, the same was dismissed, wide, and order dated 18/7/2014. Full stop. Para. Sri Saikia, the learned counsel for the petitioner, in his rejoinder, has submitted that the documents annexed in the affidavit in opposition and the additional affidavit in opposition are inconsistent, and he reiterates that at no point of time, the petitioner was made aware of the rates and also of the process that the land has been tried to be taken over by way of outright purchase. Full stop. The learned counsel reiterates that in case the land is required, it has to be taken over by following the due process of law as laid down. Due process of law connected with an acquisition proceeding. Full stop. Para. The learned counsel has also referred to the case of Tukaram ... reported in 2013 1 SCC 353 and has contended that the Honorable Supreme Court has laid down that forceful acquisition, that acquisition at all, if at all done, has to be made by following the due process of law. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court have been duly examined. Para. The projection made in the time of oral argument on behalf of the petitioner is not consistent with the prayer of the writ petition, which has already been extracted above. Full stop. Be that as it may, even taking consideration, and even if the projection made presently is taken into consideration, the principal thrust is that the land has been taken over without an acquisition proceeding, and the rates were, and the land acquisition and the land compensation has not been paid. Full stop. A question has also been raised on the procedure adopted, alleging that the same is not transparent and the petitioner was kept in dark. Full stop. Para. From the materials available on record, it appears that along with the petitioner, lands of many other persons in that area were taken over by way of outright purchase. Full stop. There is no dispute to the fact that outright purchase is the first procedure to be attempted by the Oil India Limited for in case of requirement of land, and only when the same is not possible, recourse to acquisition proceeding is to be taken. Full stop. There is also, it is also not in dispute that since the transaction, though private in nature, is with a Government of India undertaking, the rates fixed by the district administration is to be adhered to. And in the instant case, the rates per bigha is found to be rupees 5 lakh per 5 lakh. Full stop. Though there is some confusion with regard to the rate, the Learned Senior Council has clarified that the rate per bigha is rupees 5 lakhs.
As per the order dated 19th July 2005, that can be also recorded.
5 lakhs, which is also recorded in the order dated 19/5,
19th July 2005.
19/7/2005.
The Deputy Commissioner's order, page 70.
And that, yes.
It's based on this order.
Yes, yes.
this
No,
amount.
no, there is one document which says 4 lakhs. That is all.
That document otherwise refers to this 19th July itself. So it's a typographical error.
Maybe,
Philosophical fee
No, no, that is
as
clarified.
per 19th July, but 19th July is
No, no,
5
no,
lakhs.
no,
So we go by 5 lakhs.
It's 5 lakhs,
Yes.
clarified, and which is also reflected in the communication dated 19/7/2005, which has clearly indicated the rate as rupees 5 lakh per bigha. Full stop. The records, the documents placed on record would also make it clear that an application for land sale permission was duly submitted by the parties jointly, in which the signature of the petitioner appears. Full stop. Further, the communications made to the petitioner by the oil on the aforesaid transaction have been placed on record, which also contain an acknowledgement of receipt. Full stop. Though the Learned Counsel for the petitioner has denied receipt of such document, his conduct in submitting the joint application for sale, which is not disputed, would make the aforesaid aspect of non-receipt of the communications immaterial. Full stop. The projection made that the petitioner was not aware that a process for purchase of the land outright was on is not acceptable from the facts and circumstances in the case. Full stop. This court has also noticed that the rate fixed is as per the government fixation, and therefore the
prayer made in this writ petition for interfering with such fixation and directing for payment of an enhanced amount is not within the ambit of a petition filed under Article 226 of the Constitution of India. More so, when the petitioner was in his right to refuse for an outright purchase, in which case, the Oil India Limited would have to take the recourse of acquiring the land. Full stop. However, from the documents and record, the conduct of the petitioner becomes apparent, wherein he had agreed for an outright sale of the land in question and had also made the joint sale permission, and only thereafter, he had refused to cooperate, for which the transaction has not been able to be brought to a logical conclusion in the form of a registered sale deed. Full stop. In the opinion of this court, the petitioner has not only waived his right, but is also stopped from making any other claim in this regard. Full stop. Para. The documents placed on record and the pleadings would also indicate that the conduct of the petitioner in approaching a court of equity is questionable. Full stop. It is apparent that when the transactions had reached the verge of completion, the petitioner had stopped cooperating and thereafter had filed this writ petition in the year 2012. Full stop. As a result of which, the transaction could not be completed and whereas for all other owners of the adjacent plots of land, the sale price have been paid. Full stop. Para. In view of the above, discussion, this court is of the opinion that the petitioner has not been able to make out any case for interference. More importantly, with the nature of relief he has sought for. Full stop. The writ petition accordingly stands dismissed. Full stop. However, in the interest of justice, it is directed that the petitioner completes all the formalities for execution of the sale deed within a period of a month from today, and on receipt of the necessary documents, testimonials, the Oil India Limited, respondent Oil India Limited shall take all necessary steps for executing the sale deed. Full stop. It is needless to say that the petitioner would have to render all cooperation for such execution.
There will be only one issue here. The sale deed has to be executed before the sub-registrar's office. So one clarification that the rates will be up there based on the 2005 rate.
Nothing more.
Because otherwise,
nothing more. It's the same rate.
if that can be clarified, because
it is also needless to state, and it is clarified that the rates
of 2005 will be the basis.
Rates would be on the basis of the prevailing rate during the time of taking over possession.
19 July 2000, taking over possession. Yes.
Which was fixed at rupees 5 lakhs per bigha.
Yes, obliged not. So the sub-registrar's office, there will be a difficulty regarding the government rates and all. Obliged not.
Obliged.
Huh? No, sir. Oh, here to I don't. Acha, 5 minutes. We'll just rise for 5 minutes.
May I please your lordship, my lord? My lord, in this case, my lord, I have already intimated the court, the petitioner not expired. And later on, my lord, court was of the view that since the offense is against the state, therefore, my lord, court is inclined to allow you to appear as the amicus. This matter relates to my lord, kidnapping of 2 guards, my lord, in 2012. And latest report they submitted twice. And both the reports show that, my lord, victim could not have been traced out, accused could not have been apprehended. This is the position. And I have not, I don't have much to say except to, my lord, point out 2 reports which are submitted by the, my lord, government. One report is, my lord, 14/8/2023. And another is, my lord, 30/10. Ultimately, they concluded that in spite of our best effort, we constituted a team, we conducted investigation, all possible extent, but we could not trace out the victim, or we could apprehend the accused.
Where is the report, Mr. Goswami?
That is part of the act.
X.
Last line, my lord. But all are still vain, all are in vain till date. Efforts were made to trace out the victim and apprehend the accused person. This is the first report. Then one more report was called for. And that report also shows the same thing.
Just a minute. No, investigation has not been closed down as
Yes,
such. It's continuing.
still continue.
Now, what was the prayer made initially in this
Basically,
petition?
my lord, initially we approved this honorable court since there is a serious lapse on the part of the police administration in not conducting investigation. We also
But
approved the, my lord,
how were you connected with these two victims?
I'm basically, my lord, I am the de facto guardian because
How? That we have said, read.
my lord, that was in terms of an agreement because they belong to very poor family and responsibility was entrusted to me, my lord, to take care of their education, etc. I was a joint director at that point of time in the Department of Revenue. So when I was coming back,
one aspect is there, the statement of the principal of the school
my lord,
states
he has
that,
given, yes, my lord.
says that when
Yes.
the exams were over
Yes.
and they were leaving the school,
Yes.
there was an altercation
My lord.
with you and the parents of the two
Yes.
two girls.
Yes.
Now the persons who are made accused, are they the parents?
No, they are not the parents. They are not the parents. Parents, my lord, accused of somebody else. And they are coming back from the school.
Now, what is the stand of the parents?
Parents, my lord, report doesn't say, my lord, whether they were intercepted by police or statement was recorded at all.
No, the search operation says that neither the victim nor anybody could be traced out.
Now, what is the statement of the parents might have been very relevant. But the report doesn't.
That report law. That second page, the last paragraph.
Report.
Second page, the last paragraph.
Yes.
Last sentence. However, during interaction with the local respectable people of that area, it was revealed that since the date of their release from their Grace High School, Udan, Tarapur, Lakshmipur, the victim girls were staying with their parents at that locality, and later they had that place 2 days prior to visit by you.
Oh.
Had it been the position, then Roshi may get the confirmation. And I basically, my lord, I am no more at the moment. Petitioner already expired. And wife of the petitioner, she made an application for impleadment. Now, what is the fate of that application? I don't know. Court didn't pass any on.
No, she also doesn't want to pursue. Mr.
Yes.
Sinha appeared.
Sinha, my lord.
He says that I don't want to pursue.
I don't want to pursue. So basically, my lord, it is for the state and the, if court has the confidence, my lord, some investigation took place and they are staying with their parents, my lord, happily, then, my lord, what about the, my lord, the basic part, whether they are either in the offense or not?
No, but the investigation report which
Still,
has been furnished to the court says that they are still not traceable.
Yes.
Now, under those circumstances, what do you do?
And whether that, my lord, if report says they are not traceable, whether that part of the statement they are staying with their parents, whether it is acceptable or not. That was a statement made by neighboring people. And what is the statement of the parent? If parents is the best person, my lord, they would have said, yes, they are staying with her.
Where have you stated about who are you?
My lord,
Your antecedents?
yes. There are five.
There are 5. Yes. No, your antecedents? What do you do?
My lord, at that point of time, I was a joint director.
Where have you stated?
Okay. My lord, at page, Lordship kindly, assistant director,
Where?
at page 19. The petitioner is an ex-gazetted government officer and he retired from service as assistant director, survey department. And retired in service in 2002.
You had filed the affidavit or only had produced the report?
Earlier, we have filed on the.
No. The order by which the matter was not closed, but Mr. Purkasta was made the amicus. It has also said that affidavit is required to be filed. You have to file the report dated 18/14/8 along with it. 14/8, 10. Where is 14/8? Okay. Yes, what do you suggest? See, there is a statement that the children are with their
Yes,
parents.
That is a statement made by
That
other
has come up in the report of 38.
Yes.
Okay.
38.
Heard, Sri A.K. Purkasta, Learned Counsel for the petitioner. Also heard, Sri N. Goswami, Learned State Counsel, full stop para. At the outset, comma, Sri Purkasta, the Learned Counsel has submitted that the petitioner has passed away during the pendency of this case. And the matter and the subject matter, which was thought to be raised in this writ petition, is such that there may not be requirement of any further substitution, full stop. This court has also been informed that in fact the wife of the petitioner, Srimati Manorama Sinha, had filed an application for impleadment, who, however, has also submitted that she doesn't want to proceed in the case. Full stop. Para. The issue raised was with regard to two minor children of whom the petitioner claimed to be the de facto guardian. Full stop. The allegation is of kidnapping of the two children when the petitioner was fetching them from their boarding school after completion of the examination on Seven 2012. Full stop. It is also submitted that in this regard, in that regard, Lakhipur, Lakhipur PS case number 190/2012 under section 366 within bracket A /506/323/34 of the IPC was lodged, in which investigation was carried out. Full stop. Para. When the subsequent development of the demise of the petitioner and the disinclination of the wife to continue with the proceeding, this court by order dated 14/8/2023 had directed for giving an up-to-date report of the investigation. And had also requested Sripur Caste to act as an amicus curiae. Full stop. Para. Pursuant to the said order, the concerned Superintendent of Police, Kachar district has issued a communication dated 30/10/2023 to the learned government advocate, which has already been made a part of the records as flag acts. Full stop. A perusal of the report would show that neither the victim girls nor the accused persons have been able to be traced out. Full stop. However, it has been gathered that the two minor children were with their natural parents in the jurisdiction of Parampat PS, Imphal East, Manipur, and had thereafter changed their locality. Full stop, para. Taking into consideration the aforesaid facts and circumstances, and also the materials collected that the two children were staying with their parents, comma, this court is of the opinion that there is no requirement to further continue with this writ petition, full stop. However, comma, closure of this writ petition should not be construed to mean a closure of the investigation, which is directed to be completed and brought to a logical conclusion by submission of a final form under section 173 of the CRPC. Let them give a final form, it may be a final report or whatever. Or a charge sheet.
Yes.
Even if the accused are absconding, charge sheet can be given if their materials are there.
Yes. And also in a honor tell you what is my rule to.
Huh? In view of the final orders passed, disposing of the writ petition, comma, I stands closed, Ms. K stands closed, alag.
Apply.
Okay. See, there is no fruitful purpose we'll be having, keeping this pending.
Yes.
So, okay.
Only thing is the investigation may continue.
Yes, no,
And
we
it-
have
they should come to a logical
we have said that.
Yes, yes.
Closure of this will not mean
Yes,
closure of the investigation.
Absolutely.
3 and 4 years.
Yes, your lordship. It is regarding the balance of the compensation, your lordship. Your lordship has
We have heard
heard
that.
at length, and your lordship, I showed the disparity between our case and in the petition of writ petition number 1538, 2010. And your lordship was pleased to call the record, and your lordship will examine whether there is any disparity on.
Okay, you have checked the records.
Record is here, your lordship. In this case, your lordship,
1538
one of
is-
my colleague was the counsel, and I
No, we have the
remember I have drafted that
We-
petition also.
We have the records. You can have a look at the
Yes.
records.
All these cases were earlier drafted by me, and I remember, your lordship, the same case, your lordship. Land- same. The, the. 31. Yeah. Your lordship, same, your lordship, annex 3, 4, same estimate.
Mr. Goswami?
Okay. Yes, sir.
Estimate combine. Next, 3, 4, 40.
Yes, Mr. Goswami.
Yes.
Yes.
Monday.
Not Monday.
Tomorrow.
No, no, you can check the records. You can.
Yes, you're okay.
We can sit at 2 o'clock.
Look.
These are all matters.
All matter. And your lordship has also heard both sides on
But
that.
we'll have like you to refresh the matter for around say 15-20 minutes. Then we can come.
Yes, yes.
We have the look at the records.
Look.
See, we have heard the matter. Whatever little we remember, and the projection was that for similarly situated
Yes.
persons, they had also these petitioners had also approached this court on 2 earlier occasions. And in one of the similarly situated person, in pursuant to one of the orders, the entire amount has been paid.
Right.
We wanted to see whether there is any change in the situation or of the cases. That what Mr. Mazumdar is submitting is similar, analogous. If that is the case, this speaking order may not be a sustainable one. But you have a look. Okay, we'll sit at 2 o'clock.
Okay.
বাকীটো নাই আৰু নাই না? এই দুটাই আছে না? You take the case records.
Lordship, in dispose of case 153/2010, Lordship, in that case, there is a submission from the PWD council that he paid deposit the entire amount to the deputy commissioner. That is the reason they can release. But in this case, I don't know what is the status of the payment. Other amount that may be reported back to the department also.
Now, that part we can take care, but their entitlement. And how you had paid the procedure adopted, there may be some difference. But you have come to a conclusion that the persons who are similarly placed were entitled to the enhanced compensation. And for them, you have said that you could not ascertain the GRAT because he had gone at a later point of time. At that time, the structures and the trees were not there. And we are not even on the factual part. We are on the part of parity. The reason for calling for the records of 1538 is only to ascertain whether the facts are the same and it arises from the same transaction, which appears to be a correct submission by Mr. Mazumdar. Mr. Mazumdar, if you can just brush over the facts.
Yes, Your Lordship. Your Lordship. Yeah. For Your Lordship, for construction of Indo-border road, Your Lordship.
Yes.
Indo-Myanmar border road. So land were acquired by Royal of several land acquisition case. In the instant case, the land acquisition case number 24 of 2003-24, later on renumbered as 27/2007-2008. In fact, 4 numbers of land acquisition cases were initiated, Your Lordship.
Total 4.
Total 4.
Oh, 4
and
numbers.
the villages, several villages, in the item number 3, the villages needs Liverputta, part 1 village. Need Liverputta, part 1
In
village.
Tajuddin.
Lordship.
Tajuddin.
Tajuddin.
Just a
And
minute.
in
Just a minute, please. 4742.
Yes.
Name of the village?
Needs Liverputta, Leverputta,
L.
Leverputta, part 1, Lordship. In the first case. In the second case, it will be part 2.
Second case means Azizul.
Yes.
48.
4845. The village is Liverputta, part 2. And the LA case number is
Liverputta, part 2.
part 2. In that case, LA case number is 15 of 2003-4, renumbered as
15
of 2003-2004, renumbered as LA case number 16 of 2006-07.
16.
16 of
2007-8.
no 6 and 7. 2006 and 7. Your Lordship. Then Your Lordship, estimate were made. Your Lordship will find the estimates. Your Lordship may kindly see page 41.
Which
of,
petition?
Item number 3.
Tajuddin.
Tajuddin.
Page
41.
41.
Page 41. There are 4 number of LA cases.
Just a minute, please. Page 41.
four number of LA cases.
Yes.
First, LA case number 4 of 2006 and 7.
No, 4 and 29.
4,
At page 41.
yes.
Chart.
First case is LA case number 4 of 2006, 2007.
Oh.
There is a case I referred related to read petition, similar read petition 1538, 2010. They have already got the balance.
Serial number 1.
Serial number 1.
LA case.
4 of 2006, 2007. Total estimate was 1 crore 35 lakhs odd. Initially released after deduction of 20%, 1 crore 18 lakhs odd.
1538.
Yes. 1 crore 35 lakhs 48,120.
And what about 29? Second,
And
serial number
29, we are not concerned, Your Lordship.
Paid.
They have also RFs. Then we are concerned with serial number 3 and 4. Tajuddin is 27 of at serial number 4. Estimate was 1 crore 94 lakhs 38,984.
This is Tajuddin.
Tajuddin.
Serial number 4.
4.
And serial number 3.
Approved.
Azizul.
Then Your Lordship, kindly see next column.
Hmm.
After approval deducting 20%, Jirat.
Where are you reading?
At column number 3, Your Lordship.
3. Balance additional estimate.
Yes. Total estimate approved, that was paid 1 crore 68 lakhs 28,663.
Where are you reading? Page?
Page 41, Your Lordship.
1 crore 68 lakhs where? Yes, 1 crore.
Serial 4.
Okay, yes, yes.
Your Lordship got it?
Yes.
Then balance is 26 lakhs 10,321. This is 20%. This year, Your Lordship. Similarly, in next case, that is serial number 3, LA case number 16 of 2007-8. Total estimate was 3 crore 64 lakhs 86,233. Approved and paid already 2 crore 68 lakhs 50,757. And the balance to be paid is 96 lakhs 35,476. Now, Your Lordship, may kindly see page 39.
39.
39.
Yes, what is 39?
This is the letter from the additional Deputy Commissioner to the Joint Secretary, Revenue. I have the honor to state that as regard point T as mentioned in the letter, latest we held meeting with the requiring department executive engineer BSc, wherein the matter of deduction of the LA, estimate in respect of the LA cases in question, figured and discussed in detail. The requiring department did not raise any objection if the government decided to release the deducted estimate amount against the LA cases. However, a minor of the copies latest transfer is enclosed herewith in a statement showing the preliminary estimate submitted from this end. That is the next page, which I have already shown to Your Lordship. Then Your Lordship, page 42. Page 42, I am reading relevant. Kindly refer to your letter cited above regarding deduction amount in land acquisition estimate in above stated LA cases, including all LA cases. Our cases is also there. I am directed to say that you have stated in your letter that as 80% land acquisition compensation in above LA cases were paid from your end immediately after publication of the declaration following provision of the land acquisition manual to take and hand over land urgently, and affected people are now pressuring for release of the balance 20% of the compensation amount. This matter was not timely submitted by your office at the time of submission of the award, and therefore award in LA cases were approved on the basis of your demand in these cases. Now in the letter dated so and so, you have stated that the concerned PW department has not raised any objection for release of the balance fund of 20% subject to approval of the state government. Your Lordship. Then your Lordship, several correspondence were there.
Requiring department is PWD.
Yeah. According. Then your Lordship, being agreed, we filed the first round of litigation, your Lordship. That is WPC number 1746/2010, wherein the respondent has filed counter affidavit admitting our claim. Their affidavit is Annex 7, page 46. Relevant is para 4, page 47.
Just a minute, please.
Para 4. With regard to the statement made in para, so the deponent beg to state that it is a fact that an amount of rupees 26 lakhs or as 20% of GRAT compensation has been deducted by the government by letter dated so and so.
Just a minute, where is the, this thing? First, 1746 is Tajuddin.
Yes.
Tajuddin. Then
Yes.
who filed affidavit?
Lordship,
Who filed affidavit, which page?
by respondent number 4,
Page?
that is page 46, is the extra assistant commissioner on behalf of Deputy Commissioner Kachar.
Okay, what did he say?
At para 4, page 47, para 4, with regard to the statement made in para 3 of the representation, the deponent begs to state that it is a fact that an amount of rupees 26 lakhs 10,321 as 20% of GRAT compensation is deducted by the government by letter dated so and so of the state LA case not yet been paid. In this connection, it may be mentioned that the total estimate of the state LA case was rupees 1,94 lakhs, which was sent to the government in Form 5 for approval, but the government by letter dated reduced the amount to rupees 1,68,000 and approved accordingly after deducting rupees 26 lakhs 10,000. Then your Lordship.
No, but this letter would be against you. It is not a question of holding back 20%. They had said the approval was given for.
He is just placing the fact. He has also admitted that the government has approved 80%.
80,
as
yes,
paid.
yes.
I'm just bringing the fact
Okay.
that 80% has been
Okay,
paid.
okay.
Then your Lordship, all the agreement of the LA cases approach this honorable court. 3 numbers of writ petition was filed.
Hmm.
Your Lordship.
Yes.
The Pattadars of land acquisition case number 4, they filed WPC number 1538/2010. The order is at page 54 and Annex 10. I will go through the only relevant portion, page 55. Upon hearing the learned counsel, last paragraph.
Yes.
Upon hearing the learned counsel for the party and on consideration of the written instruction as referred to above, reflecting the stand of the respondent, it is considered expedient to close the instant proceeding with the direction to the Deputy Commissioner Kachar to cause necessary steps to be taken to ensure that the balance amount of compensation is paid. There was a clear direction in this case to the Pattadar involved as due to them in law. Needless to say, before final disbursement, the aforementioned authority would notify the petitioner and release them their duties on proper identification. As the petitioner waited in expression for nearly a decade after acquisition of the land, the process that director should be completed within 6 weeks from the date of receipt of the certified copy of this order. Now, as there was a clear directions, the Pattadar of this land acquisition case, they have already been paid the 20%. I have annexed some vouchers.
Yes.
But
Yes,
unfortunately,
60 and 61.
yes. But unfortunately, in our case, in our both decision petition, there is a page Annex 8, your Lordship,
56.
50, your Lordship.
50.
50, Annexure 8.
Or in your case,
In my case,
this is Barua's order.
by board of judgment, I will read only the relevant portion, page 52.
Yes.
As the counter affidavit filed by the state government is silent about the causes for not releasing the balance amount as indicated above, these courts find no impediment to issue a direction to the respondent authorities to release the balance amount in favor of the landowners, including the writ petitioner, if what has been they are entitled. Before releasing the amount, the landowners, including the petitioner claim, will be verified, and if found sustainable, rather entitled, the amount shall be released. Then, your lordship, Annexure 11, they pass an speaking order. Annexure 11,
Yes.
page 56.
Hmm.
In this case, what they have stated, the last paragraph of page 57, thus, last paragraph of page 57, thus it is clear that the Girard value were reassessed by the chief engineer, PWD building, who is the technical head of assessing department, and it was accepted by government in revenue and disaster management, and accordingly approved the LA estimate. Next page, the assessed Girards are no more in existence. God knows how they have reassessed. The assessed Girards are no more in existence on ground of re-verification, as border roads and fence have already been constructed, your lordship. So they have rejected our position. Again, challenging this common impugn order.
Just a minute, please. Yes.
Again, challenging this common impugn order, your lordship, we filed two writ petitions in two cases. Annexure 60, page 16, WPC 4434 2012 and WPC number 4435 of 2012. This is the second round of litigation, and both these two writ petition was disposed by common order, Annexure 16, page 63. Relevant is there, page relevant will start from para 14, page 69. Having regard to the above controversy raised in the writ petition, also considering the matter in its entirety, both the writ petition are disposed of, directing the LA collector to take into account, your lordship, this is important, the aforesaid plea of the petitioner and decide whether any review of the order impugned in this proceeding is called for. In any case, the said authority shall pass a speaking order, taking note of the aforesaid plea raised by the petitioner in the writ petition as well as in our additional affidavit filed on 22/3/2013, in respect of which the respondent have not filed any response. Let the exercise in terms of this order is carried out as expeditiously as possible, preferably within 13 June 2014. The petition shall be liberty to produce the order to the collector. Now, in pursuant to this, they pass again a impugn order, which is in fact the ditto of the earlier order without taking into consideration our plea and additional affidavit. If your lordship may kindly peruse Annexure 11, 12, and 11, and Annexure 17, they are in fact ditto order. Now, challenging this, the instant two writ petition has been filed a lot. And I have brought out what is the disparity between our case and in WPC number 1538 of 2010. And my learned friend had also admitted the facts are same. Even the correspondences are same, your lordship. In this case, 3, 4, 5, all same communications. A lot.
Yes,
The retribution law, the page 32 law, that was communication from the deputy secretary. to
page 32.
Okay.
10/11.
Okay.
10/11/2005.
Law.
Yes, we have this.
The necessary award statement may kindly be furnished to this department as per approved and acquisition estimate. The value of houses and ponds are corrected as per reassessment of valuations of the houses and ponds by the PWD department.
Yes,
On the basis of their loss, reassessment by the PWD department loss, that by 20% by the department.
yes, that is on 2005.
Assessment was made by the PWD department. And you know, the impediment order
Just
also.
a minute, please. Just a minute, please. 24. No, if you, if this is a letter by the Revenue Department to the Deputy Commissioner, and you say that you have arrived at the amount of 1,68 lakhs after correction and reassessment of valuation. So this is this is with regard to case number 24 of 2003-2004, correct? Now, in the chart, that is a chart which is a part of your annexure.
41.
Page 41, if you
41, then
just a minute, Mr. Mazumdar, just a minute. Okay, last paragraph of page 40, the type copy.
Page 40.
40.
Look.
It is a part of the letter of 24/9/2009.
Yes.
The last paragraph.
Okay.
Further, a statement showing the preliminary estimate submitted from this end. This end means the Deputy Commissioner. Against the LA case under government's approval of the so-and-so, and the difference is prepared and sent herewith for your kind perusal and consideration. Now, this is the chart at page 41. It is a part of the earlier letter of 24/9/2009. Okay. Now, this chart has 4 LA cases.
Yes.
1 and 2, it is submitted that 1 and 2 have the balance amount has also been paid.
Yes.
The 4th column, 1, 2, 3, 4, 5th column is balance oblique additional amount. Okay. 1 and 2 has been paid. So far as 1 is concerned, there is also a court case of 1538. Okay. 2 he is not very sure. But 3 and 4 the present petitioners. Now we again come back to the contents of this letter. What was this letter? At page 39.
Page 39.
Yes, the letter.
Look.
Please read this letter. Read the contents.
Inviting reference to the above, I have the honor to state that as regards the point number C as mentioned in your letter, that 7/3/2009, we held meeting with the requiring department. That's the executive engineer BRC on 28/5/2009, wherein the matter of deduction of the LA in respect of the LA case in question figures and discussed in detail. The requiring department did not raise any objections if the government decides to release the taxes estimate upon the LA case.
Okay.
However, a copy
See,
of-
here, pause here for a moment. Their objection would have been relevant, but no objection would be of not much relevance because the government is ultimately to take the decision. There no objection will not mean that the petitioner will get the amount. It is still left with the government. Now, however, a copy of the minutes, then a statement given. Now, it is a general statement for all the 4 LA cases. Now, the government, the department has taken a call that so far as the, at least the petitioner, at least the case number against serial number 1 is concerned, the balance amount has been paid. And that too pursuant to an order of this court. Now, in the second part of your other communications, which you have just referred at page 32.
42.
32.
No, 32. Come to page 32.
Yes.
Thirty-two. This is an existing communication. This is of 2005, isn't it? Is it 2005? Yes, November 2005. Correct? November 2005, you said the value of the houses and ponds are corrected as per reassessment of the valuation. Now, correction is another matter. 168, where is 168? 168. 168. Now, where is the 20%, Mr. Mazumdar?
Yes, Your Lordship.
20% deduction?
Yes, Your Lordship may kindly see Annexure 5, page 42.
42, yes.
42.
Hmm.
Kindly refer to your letter cited above. This is by Joint Secretary Revenue Department. It is stated allocation. I am directed to say that you have stated in your letter that as 80% land acquisition compensation in above allocations were paid from your end immediately after publication of the declaration, following provision of the land acquisition manual to take and hand over the lands urgently, and affected people are now pressuring for release of the balance 20% of the compensation. This matter was not timely submitted by your office at the time of submission of the award. Therefore, award in each allegation was approved on the basis of your demand. Now, next paragraph. Now,
Is this, was this letter of 29 October 2009?
Yes.
Responded to by the Deputy Commissioner?
Yes.
Where is the response?
Next, I will come to the next.
And where is the response?
Response is Annexure 6, page 43.
Okay.
Page 43. Married.
That's
In reference to the above, I will be honored to inform you that initially the LA estimate of all the cases were submitted, including Girard value as assessed by the executive engineer. This is also by PWD. But when the land acquisition estimate was sent to the government, the same was approved after deducting Girard value, 15%, 20%, 30%, etc. In our case, 20%. And instructed for furnishing the award as per approved L estimate. Accordingly, the award was sent and the same was approved by the government. Next page. Further, the point was reply is furnished below. Total amount of fund received by the requiring department, 19.30 crores. Total amount of fund utilized, 5 crores odd. Amount, if any, with us, which may cover the amount, 1,90,000 odd. Next, also I am to say that total deducted amount of the GR value comes to 1 crores 40 lakhs 50,594. A detailed statement in Annexure I, that is at page 45. This is the approval of the Deputy Commissioner. Page 45, again, the same balance. Page 45, Annexure.
this, where is the, do you have the original of page 39?
Page 39.
No, why you're asking is there is
Yes.
a reference at page 42.
Yes, yes.
Please, page 42, annexure 5. Okay. Page 42.
42.
Page 42.
Yes, your
This
lord.
is letter dated 28 October 2009. Have you
Yes,
got?
your lord.
And
Yes.
in the reference part, third head reference,
Yes.
the last letter is CLA 1 of 2003 dash 2004 dash 608 dated 24/9.
9.
Is it 24/9?
9.
And in the,
I have annexed the
No,
type copy.
okay,
Thanks,
no, no,
sir.
in the body of the petition, of the letter, second paragraph,
Yes.
now in your letter so and so dated 14/9, that is the creating a big problem.
Yes, yes, yes.
Number is same 608.
Number is same, your lordship.
It should be item 24.
Typographical
It
mistake.
should be 24/9 perhaps.
Typographical mistake is there.
Mr.
I
Gustami,
got
have
14 or
you
20.
followed?
Look.
I think this should be 24/9.
I see.
Then, so for 24. Collector. After this letter has been issued at page 40, 43, the reply to the Revenue Department
Yes.
by the Deputy Commissioner.
Deputy Commissioner response.
He has complied with the requirements of the earlier letter of 28/10/2009 by giving the details. Now, after that, can he, is there any occasion or situation to pass the impugned order of 23/6/2014? See, there are two issues which may crop up. One is releasing of 80% and one is correcting and holding them to be entitled to 80%. That's a different matter. Releasing of 80% and by withholding 20% is a different aspect. And the other aspect is how much total amount you are entitled to. Now, one communication says that it was corrected, which you are emphasizing at page 32. After correction, this is the amount which you are entitled, you have been paid. So there is no question of any holding back of any amount. But the other communication says that the Deputy Commissioner at that time had released 80% and this rest 20% was subject to approval. Government says that you have not given details. Give us the details. Deputy Commissioner gives the details at page 43.
Okay.
After that, it's a question of completion of formalities. Now, how can he go back now? See, 42 makes it very clear. Please read 42. I am directed, the third line, I am directed to say that you have stated in your letter that as 80% land acquisition completion in the above alleged cases were paid from your end immediately after publication of the declarations following provisions of the land acquisition manual to take over the lands urgently, and the affected people are now pressurizing for release of 20%. See, at the time of taking possession, 80% paid, 20% will be paid later. Now you have thereafter you have not given any details. Please give us the details. He gives the detail at page 43. The Deputy Commissioner. Now impugned order is passed by the Deputy Commissioner himself at page 71. Now, is there any scope to again go into the examining their entitlement? See, we understand public money has to be it's a fiduciary kind of a duty. Utmost care has to be taken. There is no misutilization or siphoning of funds. But here, the competent authority had applied mind. One party has got orders of the court. In another order, the word if was there.
The High Court order. In the page 48 law, in the two have affidavit law, page
48.
48 law.
Please.
The first paragraph, therefore, the payment of compensation may be paid to the person concerned on the risk of record fund from the recording department.
Page 48, paragraph.
Continuation of 4, no? Para 4.
Therefore.
Para 4 continuation.
Therefore, the payment of compensation may be made to the person concerned on the risk of record fund from the recording department. The payment could not be made.
Okay.
In the earlier case, that where they have got the amount lost. In that case, entire amount was deposited lost. In this case, 20% was not deposited, correct, but
This is
I
our
think,
case.
Mr. Bhattacharya,
Our case.
Mr. Chaudhary, public works may not have much of a role.
That the PWD has
No objection.
deposited the money. Thereafter, there was no communication that
You deposited the entire amount.
yes, the
Which record? But otherwise also official documents say that you do not have any objection.
Yes.
Requiring department. Okay.
yes, sir.
An order dated 23/6/2014 passed by the collector, Kachar, rejecting the claim of the petitioner for the balance amount of acquisition compensation is the subject matter of challenge in this writ petition. আমি একটু হেডিট দিয়েছো, হ্যাঁ? We are writing in 4742. দুটা কেস আছে, এটা 4742 লিখেছে, বাকি নেই অলমোস্ট এক্সাক্ট হবে, এটা মারি দিব। Para. There is a checkered history of this case, which also involves previous litigations, and a brief narration would be necessary. Narration of the facts would be necessary. Para. In the year 2000, as per the projection made by the petitioner, in the year 2003, a land acquisition proceeding was initiated in the Kachar district for construction of the Indo-Bangladesh border. Quarter. Full stop. Amongst the four numbers of such LA cases, comma, the concerned LA case in this case, LA case in this petition is LA 24/2003-2004, which was renumbered as 27/2007-2008. Full stop. It is the contention of the petitioner that as per estimate prepared, comma, an amount of rupees 1.94 crores was held to be the compensation amount, and out of the same, comma, rupees 1.68 crores was released with a deduction of 15% to 20%. Full stop. As the balance amount was not released to the petitioner, comma, released to the petitioner, comma, he had approached this court by filing WPC 1746 of 2010. Full stop. In the said writ petition, comma, the who was responsible for the
Deputy Commissioner.
The Deputy Commissioner Kachar had filed an affidavit in opposition, and in paragraph 4 thereof, comma, there was an admission of deduction of 20%. Full stop. This court accordingly, wide order dated 7/4/2011, had disposed of the writ petition with a direction to verify the facts, and if found sustainable, to pay the amount. Full stop. It is the case of the, it is this specific case of the petitioner that similarly placed incumbents had filed another writ petition, WPC 1538 of 2010, in which there was a direction of this court, wide order dated 11/11/2010, and in the said and in the concerned LA case, namely LA case number 4/2006-07, comma, the amount, the balance amount was released pursuant to the aforesaid order of this court dated 11/11/2010. Full stop. The para. However, full stop. The case of the petitioner is that while the balance amount in a similarly situated case was paid, comma, a speaking order was passed on 21/7/2012, wherein some irrelevant observations were made resulting in denial of the claim, full stop. Para, the petitioner accordingly filed the second writ petition WPC 4434 of 2012, full stop. This court, wide order dated 3/4/2014, had disposed of the writ petition, remanding the matter in which the ground of disparity was also taken into consideration vis-a-vis the incumbents in LA case 4/2006-2007, full stop. On such remand, the collector, Kachar, has passed an order dated 23/6/2014, by which the claim of the petitioner has again been rejected. Full stop. It is the validity and correctness and legality of the order which has been questioned in this writ petition. Full stop. Para. I have heard Sri R. Mazumdar, learned counsel for the petitioner. Full stop. I have also heard Sri N. Goswami, learned state counsel, Sri B. Chaudhary, learned standing counsel, PWD. Here for Revenue Department, Miss, and Sri A. Bhattacharya, learned standing counsel, Revenue Department. Full stop. Para. Sri Mazumdar, the learned counsel for the petitioner, has submitted that the impugned order dated 23/6/2014 is not sustainable in law, inasmuch as there was no occasion on the part of the collector to decline the claim, as the same was already adjudicated in the earlier rounds of litigation. Full stop. It is submitted that the materials on record would show that 80% of the estimated amount was paid from the end of the collector, as there was urgent requirement of taking over possession, and the rest 20% was to be paid later, which later, full stop. However, due to late furnishing of certain details, the said balance amount was not paid. Full stop. Para. The learned counsel for the petitioner has also submitted that the earlier speaking order dated 21/7/2012, which was the subject matter of challenge in the second writ petition WPC 4434/2014, was interfered with, and the matter was remanded by this court, wide order dated 3/4/2014, wherein a specific observation on the ground of disparity was made. Full stop. It is submitted that the said observation of this court has not been taken into consideration at all, and on the same grounds as recorded in the earlier order dated 21/7/2012, comma, the present impugned order dated 23/6/2014 has been passed. Full stop. Para. Sri Muzumdar, the learned counsel, has also submitted that the authorities are required to maintain transparency and parity, and so far as LA case number 4 of 2006-2007 is concerned, comma, the balance amount has been paid, full stop. He also submits that as per information received by him, comma, even for LA case number 29/2007-2008, comma, the balance amount has been paid, full stop. Para, the learned counsel accordingly submits that the writ petition be allowed and a direction be made for payment of the balance amount. Full stop. Balance amount. With interest. With interest, huh? Para. Per contra, comma, Sri N. Goswami, United States Council, has submitted that the speaking order dated 23/6/2014 have cited grounds which are reasonable and cogent, and therefore no interference is called for, full stop. He has also referred to the communication dated 10/11/2005, wherein it has been stated that the value of the houses and ponds were corrected as per reassessment. Full stop. He has also submitted that the present case cannot be equated with LA case number 4 of 2006-2007, as the facts were different, and the order passed by this court in the said case and passed by this court in the writ petition 1538/2010 pertaining to the said case is also different. Full stop. Para. Sri A. Bhattacharya, learned Standing Council, Revenue Department, has endorsed the submission of Sri Goswami, the learned State Council. Para. Sri B. Chaudhary, learned Standing Council, PWD, has submitted that the PWD, being the requiring department and the stand of the requiring department being reflected in the document, comma, he would stand by the said stand, full stop. A perusal of the communications containing the material, containing the stand of the requiring department, is that no objections were raised on the claim by the petitioner. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. It is not in dispute that 4 numbers of LA case were instituted with regard to the acquisition proceeding for land for development of the Indo-Bangladesh border. Full stop. It is also not in dispute that the lands connected to the 4 numbers of LA case are similarly situated, and the procedure adopted was a uniform one. Full stop. The petitioner herein had approached this court for the first time by filing WPC 1746 of 2010 with a claim for payment of the balance amount, which has been quantified as rupees 26,10,321. Eto tata underline korche eto amount bodlibo. This court had disposed of the aforesaid WPC 1746 of 2010 by order dated 7/4/2011 by directing a verification, and if the claim was found sustainable, to pay the amount. Full stop. Subsequent thereto, a speaking order was passed on 21/7/2012, wherein the claim was rejected on the ground of a reassessment done in the year 2005. Full stop. It has been contended that when the land was taken over in the year 2003 itself, a proper reassessment of the Jirats in the year 2005 was practically impossible. Full stop. Though in the second round of litigation, namely WPC 4434 2012, the matter was remanded back by this court wide order dated 3/4/2014, mainly on the ground of disparity, it appears that the impugned order dated 23/6/2014 has been passed by the collector, Kachar, citing the same grounds as the earlier speaking order dated 21/7/2012. Full stop. Para. This para. As a submission was raised on the earlier occasion that the facts in WPC 1538/2010 may not be similar, this court, by order dated 14/3/2024, had directed listing of this case along with the records of WPC 1538/2010 and accordingly, the said records have been placed before this court today, full stop. A perusal of the same, including the order dated 11/11/2010, passed therein, would show that there is no discernible difference in the claim made by the petitioner in that case and the present claim. Full stop. It is also not disputed that pursuant to the order dated 11/11/2010, by which WPC 1538/2010 was disposed of, comma, the balance amount was paid to the petitioner in that case. Full stop. The only difference is with regard to the orders of disposal of the respective writ petitions, and as in the present case, comma, a direction was given to verify and pay if found sustainable. Full stop. Para. This court has also noticed, this court has also noticed that the aforesaid ground of disparity has been specifically taken into consideration by this court in the second writ petition WPC 4434 of 2012, which was disposed of on 3/4/2014, by which the matter was remanded. Full stop. Para. A close scrutiny of the documents placed on record would show that wide communication dated 24/9/2009, comma, the Revenue Department, the Deputy Commissioner Kachar had informed the Revenue Department, comma, Government of Assam, that on the subject of deductions made, comma, the requiring department did not raise any objections for payment of the deducted amount, and the matter was accordingly left to the government to take an appropriate decision. Full stop. Along with the said letter, comma, details of all the 4 LA cases were given, including the estimated amount, comma, approved amount, and balance amount to be paid. Full stop. The Revenue Department responded to the aforesaid letter wide communication dated 28/10/2009, whereby certain details, including statement of funds received from the requiring department, were sought for. Full stop. To be more specific, comma, the following informations were sought for from the Deputy Commissioner, comma, Kachar, page 42, last word can 1, 2, 3, 4. 1, 2, 3, 3 আছে। Para. The Deputy Commissioner accordingly vide communication dated 15/12/2009 had informed the Revenue Department had furnished the Revenue Department the details sought for, along with details sought for, including the amount of funds received from the requiring department, funds utilized so far, and amount remaining which may cover the 20% balance. Full stop. Para. When the aforesaid exercise was completed and it was only the details which was sought for from the Deputy Commissioner / Collector, Kachar, the question arises as to whether there was any further scope to decline the claim of the petitioner. Full stop. The first speaking order dated 21/7/2012 had cited a reason, had cited a ground that reassessment was done in the year 2005, as per which no zerats were found. Full stop. Apart from the fact that such consideration was irrelevant as the land was acquired in the year 2003 itself, the said order was interfered with by this court by the order dated 3/4/2014 in WPC 4434 of 2012, and the matter was remanded back. Full stop. As indicated above, the issue of disparity vis-a-vis LA case number 4/2006-07 was also taken into consideration. Full stop. The impugned order dated 23/6/2014 appears to contain the same reasons as the earlier order dated 21/7/2012. And it appears that a mechanical approach was taken to while considering the matter. Full stop. This court is of the considered opinion that when the entitlement of the petitioner was not disputed in principle, as would be evident from the series of communications mentioned above, there was no occasion for the collector, Kachar, to examine the aspect of entitlement. Full stop. This court, there is another aspect of the matter which is worth mentioning. Full stop. In the first round of litigation, that is WPC 1746 of 2010, the Deputy Commissioner had filed an affidavit in opposition in which there has been some admissions, no, file an affidavit of opposition, full stop. The averments made in paragraph 4 would be of immense relevance, which is extracted herein below, page 47, paragraph 4, full stop, para. When the deputy commissioner, comma, on affidavit had taken the aforesaid stand that the compensation may be made to the petitioner on receipt of the required fund from the requiring department, comma, the collector, deputy commissioner লিখিছো নাকি? The deputy commissioner of the collector, Kachar, could not have taken a separate stand which is reflected in the impugned order dated 23/6/2014. Full stop. Para. This court, as indicated above, comma, the records of WPC 1538/2010, which were requisitioned, have been perused, and it transpires that the petitioner in the said case is similarly placed with the petitioner of the present case, and only because of the language employed by this court in disposing of the said writ petition, only because of the difference in language employed by this court in disposing of the two writ petitions, comma, a separate treatment cannot be given to the petitioner in the present case, comma, more so when the claim oblique entitlement appears to have been admitted by the concerned department via the communications on record, full stop, para. In view of the above, comma, this court is of the view that a case for interference is made out, full stop. The writ petition accordingly stands allowed, and the impugned order dated 23/6/2014 passed by the collector, comma, Kachar, is set aside and quashed, full stop. Consequently, comma, the balance amount of rupees
26.
It's only the petitioner.
Petitioner. Balance amount as claimed by the petitioner be released. Not as claimed, no, balance amount as per the
Page 41.
as per the calculations made by the authorities is to be paid to the petitioner within a period of 60 days from today. Full stop. What about the interest? Land acquisition says 100% solicium.
That's a lot.
2003 your ship.
The aspect of payment of interest on the balance amount is, however, left to the authorities to be decided strictly in accordance with law. Writ petition accordingly stands allowed.
Second case, your lordship.
Second is same.
Same. Only the LA case,
That we have.
first round of WPC, number is different.
Just give the difference.
LA case, your lordship. 15 of 2003-4.
In this, it was 24.
Yes.
what is the Azizul? Azizul.
Azizul.
Azizul is 4845.
Yes, your lordship.
LA case লিখিত
15
15
oblique 2003-04,
renumbered
renumbered as 16 oblique 2006-07.
607.
Then first round of litigation, order is same, WBC number 1768,
First round
1768,
WPC 1768
68,
of 10.
2010,
Order is same.
same,
74.
74.
Same age barwa.
Same date,
order.
same date.
Same order.
No, the different order, but of same date.
But wordings are same.
Yes, yes, yes.
Yes, okay.
Then second round of litigation, WBC, it will be 4435
4435
by oblique 2012
4435 of 2012.
is a common order, same date.
Same date. That is a of 34.
Yes.
3414.
Yeah.
Yes. Common order. Okay. And
And the
impugned order
claim amount is impugned order common.
236.
Yes, yes.
Okay. Claim amount we have not reflected claim amount.
Because your lordship has not quoted it.
We're not touched. Okay.
Oblige, your lordship.
আচ্ছা এইটোতে মই ৰেকৰ্ডটো কল ফৰ কৰিছে এইটো ঘূৰাই দিবৰ কাৰণে ক'ব লাগিব নালাগে নহয় এইটোতো ইয়াৰে ৰেকৰ্ড কোৰ্টৰ ৰেকৰ্ড ইয়াৰে এইটো কিবা এটা ক'ব লাগিব নেকি নালাগে অ'কে ये चाहिए हाँ